and possessing alcohol and stops their purchase. So a common misconception about this is that it just stops you from purchasing from takeaway outlets. The scanners stop people from purchasing from takeaway outlets, but the actual order and the legislation bans people from also consuming and possessing alcohol. So a little bit of a history with some alcohol policy thrown in for good measure as well. So BDR was introduced in September 2017 when the Act was passed. Went along reasonably smoothly for a few years. Then some changes happened in government. The Stronger Futures legislation, the Commonwealth legislation, ended after 10 years. Alcohol protected areas were removed, allowing alcohol back into communities. At that stage, it was an opt-in model. So alcohol protected areas were no longer alcohol protected areas, but they could choose to be if they wanted to be. There were some problems ensued, particularly in Alice Springs. So a few months later, some more restrictions were brought in Alice Springs, Monday, Tuesday takeaway alcohol closures, restricted hours and restricted transactions as well. In the background, they're working on amending the Liquor Act. And then what happened was the alcohol protected areas were reintroduced as interim alcohol protected areas. So the dry communities became dry communities again, and it changed to an opt-out model, which is what we're currently operating under. So at the moment, communities can choose to opt out of being a dry community if they want. They can gather people who speak for the community and come up with a community alcohol management plan. And submit that to the Director of Licensing and plan on how they're going to manage alcohol in the community. At the same time, some amendments were being made to the BDR legislation. They were passed in November 2023 and rolled out in December 2023. And they introduced 7-day BDOs, so brief BDOs for BDO as a banned drinker order. So they were for things like protective custody episodes and alcohol infringements, which hadn't been an automatic BDO before. They also made the police BDOs mandatory. So previous to that, police had discretion on who they could put on the BDO. That removes the discretion for police. So they're all mandatory triggers now. A little bit about the Act. So passed in September 2017. Initially, the object of the Act was focusing on preventing people who are misusing alcohol from severe or serious harm. It was originally individually focused. Over the last few years, it's become more focused on others as well. So protecting children, addressing antisocial behaviour. And yeah, the focus has kind of grown over time. There's no criminality associated with breaches. So if somebody's on a banned drinker order and they breach that, what happens is generally that the order will be extended and there's nothing that goes on a person's criminal record, which is different to the old alcohol protection orders if people are around at that time. Protecting other people is now a focus, particularly children from harm or nuisance resulting from the misuse of alcohol by others. There is only one offence in the Act, and that is the secondary supply offence. So that is supplying alcohol to a person subjected to prohibition. Currently, the penalty is 100 penalty units, so that's up to a $19,000 fine at the moment. It's pretty steep. I will pause every couple of slides and give people a chance to ask questions if you have any. So are there any questions now? Okay, I'll plug on through. So that is the number of people who are on the banned drinker register as of 31st of May. And that represents about 1.6% of the Northern Territory population, of the entire population, which is a large number of people. I'll do a little bit of a breakdown of that in a moment. There are 4 different ways that people can come onto the BDR. So the clients and patients that you're working with may already be on the BDR through one of these pathways. So there's the registrar pathway, which my office looks after. We deal with self-referrals, authorised persons referrals, and family and care and guardian referrals. There are court-based interactions. The court can place people on alcohol bans as part of an order or on bail conditions. Police have mandatory triggers, and there's a corrections pathway, mostly for parolees as well, who have alcohol bans. So these are the police BDOs. So there are two different types of police BDOs. So there's the 7-day ban triggers, which can be protective custody episodes, alcohol-related infringement notices, banning notices, or consuming of alcohol in a prohibited public place. For the first occurrence, it's a 7-day ban. Second occurrence, also a 7-day ban. And after that becomes 3-month bans and can blow out to 12-month bans as well. For more what are considered more serious behaviours, so for alcohol-related offences or alcohol-related domestic violence orders, they start at 3 months, and then if it's breached, it becomes 6 months and then 12 months. That's kind of how the police pathway works. The court and corrections pathways. So they're a little bit different to the police and the registrar BDOs because the court have more powers that they can use, and they can make orders for longer than 12 months, which registrar and police can't do. And they can also design the orders in the way that they choose, so they can be partial alcohol bans, and they have a lot more discretion. This is the breakdown of people who are on the BDR by pathway. So overwhelmingly, the largest amount, the proportion of people is the police pathway and the courts pathway. What I'm mostly going to be talking about today is the ban drinker register pathway, which is only 3% of the entire BDR population, which at the moment is around about 160 people. Okay, so the different BDR registrar issued orders that I work with are self-referrals, so people putting themselves on the ban drinker register. Authorised person referrals, which we'll go into in more detail. And family carer and guardian referrals. So we do get a few referrals from families and from the public guardian office occasionally as well. Somebody tell me if I'm talking too quickly too, because I do that sometimes when I'm anxious. So the self-referral pathway. Anybody can put themselves on the BDR at any time by contacting the BDR office. They don't need to give a reason for doing it, and they don't need a reason to revoke it either. It can take up to 2 business days to process either way, so to go on and to come off as well. The process is the person fills out the form, which is available on our website, lodges it to the BDR registrar. We confirm identity, add person to the BDR for a period of 3, 6 or 12 months as per applicant's request, and they get a notification that their self-referral has been accepted and they're on the BDO. We do contact people who've never been on the BDR before, and ask them questions about, do they think they're going to be okay? Will they need any support? Would they like a referral to a withdrawal service or to a treatment service? So that's something we offer to everybody who's unique to the BDR. I see Fiona has a question. Slightly slower talking. Cool.
Fiona, your mic's off. Did you have a question?
Oh, yeah, sorry. I tried to talk before, but my mic was externally off.
Restricted. Sorry.
Okay.
Yeah, that's okay. So
I saw you were typing.
yeah, and I was trying desperately to type.
Yep.
So you're just wondering in the past when I've made supported a person to make a self-referral application.
Yep.
The previous registrar said that person still needed to demonstrate that they met the criteria to have one applied, which means they or someone else was at risk, was using alcohol, and it was putting them or someone else at risk of harm. But that's not the case anymore.
It is the case with authorised person referrals, but it's not the case with self-referrals.
Gotcha. Okay,
Yep.
that's great.
So how to help a person navigate the self-referral pathway. You can explain how it works, that people can put themselves on at any time. They don't have to give a reason. They can take themselves off at any time just by calling the office. Provide a person with resources from the website. I'll give you the link at the end. Facilitate a chat with the registrar. I'm happy to talk to anybody at any time who wishes to go on the BDR and talk about treatment services and anything they might need support with. You can help them with completing the application, attaching photo ID, etc. And you can facilitate their request to revoke a self-referred BDO, which is either a phone call or there's also a form that you can submit to revoke it as well. Now, some positive observations and some limitations of self-referral BDRs. So on both sides of the equation, the person has complete control. So it is both empowering and it's very easy in a weak moment to ring up and say, I'd like to come off it as well. It is discreet and confidential. Nobody else has access to the register other than police. Can reduce humbugging. This is actually a really common reason that particularly older Aboriginal people will put themselves on the BDR because they're sick of being asked to buy grog for people. So they'll ring up and say, I'm sick of humbugging. Can you put me on the order so I can show it to them? And they won't ask me anymore. We do that quite regularly. It is revoked, no questions asked. We've got a useful self-assessment tool in there. And what I mean by that is that if a person finds themselves putting themselves on the BDR once every 3-6 months and putting themselves on, then taking themselves off it, and then putting themselves back on again, it can be a way to sort of trigger the thought that maybe I might need some more serious alcohol intervention. So that works for people sometimes. We do sometimes see authorised persons referrals coming in after 2 or 3 self-referrals when people say, look, I take myself off too easily and I'd like to not be able to do that. It can be an effective tool for those who drink at home. So if the only way that a person's accessing alcohol is by going through the bottle shop on the way home from work, for example, it can be really effective for that group, for that cohort. The limitations, there is no ID required to consume alcohol at a licensed premise. So a person is banned from consuming at a licensed premise, but there are no scanners over the bar. And they're sometimes considered to be less serious than other type of bans. So sometimes you have people more prepared to secondary supply to people who are on self-bans than who are on authorised persons bans. Now, the authorised person pathway. So these are the occupations who are authorised persons automatically. You don't have to apply to be an authorised person. So anyone APRA registered, child protection workers, social workers, police officers, public housing safety officers, and sobering up shelter team leaders. Also counsellors, so level 4 ACA counsellors as well. Okay, so there are only 2 basic criteria for the issuing of an authorised person BDO. They are that the alcohol is misusing or has misused alcohol, and that the misuse of alcohol is a risk to the health, safety and well-being of the adult and or any other person. These cannot be automatically revoked. There are a couple of ways that somebody can come off one, which I'll go into in a further slide. So a common scenario for health practitioners are some of the below here. Significant physical mental health concerns exacerbated by alcohol use, increasing levels of alcohol-related risky behaviour, interfering with medication compliance. One recently, a gentleman, insulin-dependent diabetes, type 1 diabetes, would drink, forget to take his medication, had something like 12 hospital admissions within 2 months for not taking his medication. So that was a referral that came in. Relapse prevention or harm reduction purposes are some of the best reasons that people are referred for. So often the way that those work are that a person will say, I've been on a self-referral ban before. I find it too easy to come off it. Can you please help me to go onto the BDO where I can't remove myself from it easily? And there's other reasons as well. Alcohol consumption during pregnancy or breastfeeding. We often see those from child protection referrals. Now, referring a person to the BDR is not mandatory for anyone other than police, and police are automatic triggers for offending behaviour and for protective custody and infringements. So nobody is compelled to put anybody in the BDR. Here's an example for some of the AOD community services, so a psychosocial referral. So Mr. Smith has self-reported misusing alcohol for the past 12 years. Prior to entering treatment, he was consuming a bottle of rum per day with no alcohol-free days. So that's establishing a pattern of alcohol misuse. Mr. Smith reports his misuse is jeopardising employment, affecting his mental health, impeding his ability to participate in children's lives. Partner is experiencing anxiety because of his unpredictability while intoxicated and ready to leave the relationship if nothing changes. So that's demonstrating harm to both self and others. And he's completed a Medicaid withdrawal, commenced counselling with our service. He wants to achieve 3 months of abstinence while reassessing his alcohol use. Said he doesn't trust himself with a self-referral that can be easily revoked. So he's asked me to submit an authorised person's referral on his behalf so he cannot revoke himself, which is a reasonably common scenario that we see coming from AOD treatment services, so from counselling services or from rehabs, for example. Just put your hand up if you have any questions. Okay, so family referrals. This is an actual example, this one. A daughter of a person submitted a referral, worried about her mother's drinking and the effect it was having on the family and mum's health. She had pancreatitis, quite serious pancreatitis. So the registrar contacted the referrer, explained the process that her mother would need to know about the information in the referral and who referred. So that is a requirement of us that if a family member refers, we contact the registrar, or we contact the person being referred, and we give information about what's in the referral and who made the referral as part of natural justice. The registrar must refer her mother for assessment. Unique to family referrals is that family referrals all must be referred for assessment, and that will be done at one of the NTG AOD services generally. It can take a while, it can take up to 6 weeks, and it can take much longer than other pathways such as self-referral and authorised persons. So they may be more expeditious if a family member wants to refer to get in contact with a health practitioner or a counsellor or somebody who can make an authorised person referral. It's still possible to make family referrals, but they are much more difficult to get across the line, and they can cause problems within families sometimes as well if people aren't happy about being referred. So she decided to continue, spoke with her mum about the referral, and despite her concerns her mum wouldn't attend an assessment, she didn't attend an assessment. It was a really positive outcome, actually. She went to the assessment, detox was recommended, she went to the withdrawal unit, and then did ongoing case management. So it was, we did a short order, a 3-month order. So that was a positive family referral. Here are some of the steps. So anybody who is authorised to make a referral can call us up or email us and ask the BDO status of the person so that you don't waste your time putting in an application for somebody who's already on it. Referrer completes the referral form. The registrar reviews the application. If there are any particular risks that you think would make the referral more urgent, please put them in there and we will process those more quickly. We can contact the police for additional information. So in the consent and information sharing part of the Act, the registrar has the ability to seek information from police about a referral. Sometimes that's actually what gets the referral across the line is the information contained in the referral and the police information as well, and the information contained in the portal. So sometimes even when an application doesn't seem super strong, if there's also information from police and the information available on the Bandrinka Register portal, it can get it across the line. So consideration to whether a person should be referred for clinical assessment before making a decision. So if there are some big red flags that this person might have some withdrawal-related complications, we can make a referral to one of the AOD treatment services for an assessment to make sure that we're not going to put a person at risk by cutting off their alcohol supply. We do that quite regularly. Decisions made, we send a copy of the BDR in the mail and the referrer gets notified of what the outcome was as well. So this is the decision-making process or the determination process. We can take into account a person's BDR history, previous referrals received. If the criteria are met, we issue a BDA for either 3, 6 or 12 months, depending on the level of risk identified. All of the decisions are reviewable by NTCAT, by the Civil and Administrative Tribunal. You are protected in making referrals in a way. The registrar is kind of there to protect you from the appeals process. So the person making the referral is not the decision maker, the registrar is the decision maker. So it's me sitting in front of NTCAT if somebody challenges the decision and not you. A copy of the written decision can be provided on request. So people can access all of the information through freedom of information. So just like case noting, be aware that at some point in time, somebody might read what you've written in your referral. The role of the registrar. So my role is that I remain impartial. So I take into account what the referrer has to say, what the person has to say in response. We always try to contact people before making a referral, give them a chance to explain their side of the story. Ensure where possible procedural fairness requirements are satisfied and refer for assessment if appropriate. If we're worried about somebody having complications with withdrawals, we'll make a clinical assessment referral. And procedural fairness is giving a chance for the person to respond and to know what's been said about them in the referral. In those conversations where we contact a person prior to making an order, we don't give out the individual's name who made the referral. They can request that through freedom of information, but we'll normally just talk about it's child protection who've put a referral in, or it's, public housing or somebody from NT Health has put a referral in. So don't identify the person in the phone conversation, but that can be requested at a later date. We'll always encourage, if we have a chance to talk to somebody, engagement with therapeutic supports where possible and appropriate. The issuing of a BDO in isolation will unlikely be the most effective tool. So I don't think the BDO has ever completely stopped anybody from drinking. It can be a really effective tool when used as part of a relapse prevention plan, say when somebody's leaving rehab or after being in the withdrawal unit or as part of a counselling treatment plan, but in isolation, perhaps not the most effective tool. Okay, so ways that people can reduce or have their authorised person referrals revoked. Section 25 of the Act talks about therapeutic programs. So the registrar can vary or revoke an order if the person has participated in and completed a therapeutic program. The therapeutic programs are not defined in the Act, but what we're generally talking about is if somebody has completed a course of counselling to the counsellor's satisfaction, a rehabilitation program, or met their goals as part of a rehab program, evidence ongoing participation in a self-help program. So Smart Recovery, for example, have attendance sheets that the facilitator can complete. They can be submitted as evidence. Or somebody who's completed withdrawal and then, stayed linked in with the service and done some case management for a period of time, and the case manager's happy to write a letter on behalf of the client. It does seem a little bit counterintuitive for abstinence-based programs for somebody to complete a program in order to be able to purchase alcohol again. Probably more appropriate for harm reduction or harm minimisation programs where the goal might not necessarily be abstinence. It might be having a break for a while and then trying to drink more responsibly afterwards. Court-ordered bans and bail conditions, this does not apply to, so it only applies to registrar bans and police bans that can be reduced. Generally, 3-month bans are not appropriate for this because by the time a person finishes whatever program they're doing, it's probably due to expire anyway, so more likely for 12-month bans or occasionally for 6-month bans. I've changed my mind and wish to withdraw my consent is not a permissible reason under the legislation. This does happen. So people will go into a withdrawal program. They will talk to the doctor or the nurse in the withdrawal program. They'll be all enthusiastic about going on the BDR. I'm going to change my life. And then three weeks later, things have changed and they don't want to be on it anymore. That's not sufficient reason to come off the BDR. Fiona, so you put your hand up.
Oh, hi, Leon. In the past, if you're on a 12-month ban, you could only have it reduced by a maximum of 6 months to 6 months. And if you're on a 6-month ban, you could only have it reduced by a maximum of 3 months to a 3-month ban. Is that still the case or has that changed?
It can be revoked. They're not often revoked, but there is provision in the legislation to revoke a ban as well.
So, but if I have a 12-month ban, I can have it reduced by 9 months or 3 months. It doesn't have to be a maximum of 6 months. Is that right?
No, it doesn't have to be a maximum, no. Okay. Not as part of the legislation. That was more of an internal process previously.
Okay.
So, yeah, the wording of the legislation actually says vary or revoke. This is the application form that people here would most likely be using. Pretty basic. So you just need to describe the current or previous pattern of alcohol misuse. It doesn't have to be current, but hopefully recent. How it's placing the person's health, safety and wellbeing at risk. If it's affecting other people and placing their wellbeing and safety at risk. And a line about, did you talk to the person about it? Are they aware of the application or not? And is there consent and what's the level of insight as well? For health services, discharge summaries are really helpful. If you can submit a discharge summary, it will often speed up the process a bit. I would hope that most health professionals are having conversations with people before referring them. There might be some circumstances where that's not the case, but I would think most community services would be always part of a treatment plan that they're referring people for. It's a little bit different in the child protection and public housing and police spaces where there's different risk issues involved. But yeah, preferably you don't have to have a conversation with the person about it. You're quite welcome to refer people without. But I don't know, it's empowering and it's person-centered to be able to do that. So I like those applications. I guess some observations of authorised person referrals. It's effective when the alcohol-related risks relate to others. So child protection referrals almost are always about children rather than about the individual. Can be an effective tool for remote mental health patients. It does become a criminal offence to supply alcohol to a person on a BDO. They can get a reduction or a revocation of the order if they complete a treatment program, which can provide motivation to engage with services. Can be another option prior to other interventions. So child protection, for example, will sometimes refer people to the BDR and see how that works before taking more serious interventions. Or notification to a professional body for professional people. Can be helpful to address duty of care obligations in some situations in acute health applications. Some of the limitations are, and the biggest reason why health professionals often don't refer people to the BDR is that it can jeopardise the individual therapeutic relationships with involuntary referrals. I don't think referrals made in conjunction with the person as part of a treatment plan are going to jeopardise the therapeutic relationship, but a non-consenting referral can jeopardise the relationship. And people have many ideas about the BDR and whether they agree with it or don't agree with it. And that's all fine too. It's not mandatory at all. No ID required to consume alcohol at a licensed premises. So even though a person's banned, there are no scammers out of the bar. So that's a limitation. It can be an incentive to consume other alcohol products. So non-beverage alcohol products like hand sanitizer and mouthwash, and can lead to disengagement from attempting to get help. So if somebody presents to a service, has an application to the BDR made about them without their knowledge, they may be less likely to return to the service. Okay, so from the legislation, a person who applies to the register for a BDO may give the registrar any information about the adult to whom the application relates. Anyone who is an authorised person can check with the BDR registrar if a person's on the BDR before making a referral. The information is shared in order to assist the authorised person. Assist the registrar to determine if a referral is required and must not be used or disclosed for any other purposes. And you do not need the person's consent to make a referral, but it is preferable. In cases where people are requesting to have an authorised person referral made on their behalf, like Fiona was saying before, we still have to meet the criteria that the person's misusing alcohol and there is harm as a result of misusing alcohol. So Ms. Dixon asked for a referral, please make it, is not enough to justify making an order. But it is enough for a self-referral. We have these fact sheets on the website. Guides you through making a referral and the things to include and things to note, including the criteria. We've already been through this slide. Sorry about that. Other things to note. So 60% of the BDR population are eligible to have a reduction or revocation. That's anybody who's on a police BDO or a registrar BDO. The registrar can extend the period of a BDO upon request, usually via child protection or public health, but any authorised person can can apply to have it extended if the circumstances haven't changed over the course of the order, or if the risk has increased, you can apply for an extension. A person who applies may give us any information, and all correspondence to the BDR office can be obtained by the referred person via the Freedom of Information Act. Income management orders are also part of the BDR, but they're extremely rare, and it's a little bit cloudy about whether we really have the power to do them, so we generally just don't make income management orders. Now, some resources. So pretty much everything I've talked about today is available on the Ban Drinker Register website. There are fact sheets, there are tips on making referrals, tips on how to have conversations with people. All the application forms are on there. There are also monthly reports. They stopped for a little while, but they've just started again this month. So you can see a good breakdown of the BDR numbers in the monthly reports. There have been 3 separate evaluations that are on the website. There's a process evaluation, a 12-month evaluation, and a 24-month evaluation. There is another study that's going to go up there fairly soon that's almost completed. So that's great for researchers, or if you're interested in looking at the